The city is going to court to protect evidence uncovered by ethics investigations of Kathy and Louis Kealoha, findings that later played a role in the ongoing federal criminal investigation. Gina Mangieri is always investigating. Gina?
The Kealoha's civil attorney is trying to undo parts of a confidentiality agreement protecting who can see documents and evidence that the feds had already subpoenaed anyway. The city is going to court to enforce keeping it under wraps, but have to do it in court just after a lengthy and costly lawsuit brought by the Kealohas was dismissed. In the summer of 2016, Honolulu's police chief and his wife filed a 1,000-page lawsuit saying a federal grand jury, which has since delivered indictments, can be traced in part to what they called vindictive and illegal investigations by the Honolulu Ethics Commission. Taxpayers covered the tab authorized to $700,000 in outside counsel to defend the city, Chuck Totto, who resigned as ethics director just before the filing, and former ethics investigator Letha DeCaires, a retired Honolulu police captain.
Never should have been filed. It should not cost the taxpayers. It does cost to go ahead and work towards untying all of those knots, and it was very expensive.
The case was finally dismissed just over a month ago, but only after attorneys opposing the Kealohas put up the ultimatum: sit for depositions or let it go. The case was dismissed and came with a protective order designating much of the case material as either confidential or for attorneys' eyes only. Just last month, the city got word the Kealoha's civil attorney, Kevin Sumida, was challenging those protections, and the city has now asked the court to make them stick. Why is it important to protect that evidence?
Well, it's mandated by the rules and by the statute that the investigative files are confidential. But the more important thing whenever you're investigating anyone is to ensure that the people who are witnesses to the matter feel comfortable bringing it forward. This is certainly a circumstance that there's a heightened concern related to the actions that have occurred, not necessarily in this case, the civil case, but certainly as reported that the Kealohas have been involved with efforts to try and impact witnesses in their criminal case.
The FBI subpoenaed the Ethics Commission investigative files prior to their indictments. But if it's pertinent either to their case to prosecute or to the defendant's case as exculpatory evidence, shouldn't the feds have to share it anyway?
Well, under the federal rules and the law, they certainly would be providing it to the Kealoha's criminal defense attorneys. They shouldn't be trying to utilize a civil case to defend their federal case.
The Kealoha's civil case attorney disagrees, telling Always Investigating it is believed that there may be important evidence within those documents which, if brought to light, will materially assist the defense of the criminal case and which, while well known to federal prosecutors, have been concealed. The Kealoha's attorney adds the protective order agreement specifically allows this very challenge process to the scope of secrecy. The protective order case had a status conference just this week. It remains to be seen what, if anything more, can be seen from those secret files. As for that underlying dismissed civil lawsuit, it can be refiled if the Kealohas choose after their criminal case is resolved, whether through dismissal, plea, or conviction. Back to you.